By way of introduction, I am Carly Forrest. I'm a partner and solicitor advocate in the insurance and risk team at Brodies, and I deal with defence of all types of claims. There is never a dull day, but my kind of specialist subject is in relation to fatalities and serious injury claims. And today, speaking with me, we've got Lynn Livesey, who is a legal director in the insurance and risk team, and Lynn has a specialist interest in the healthcare and clinic sector. So what are we talking about today? Well, Lynn is going to give an overview of the types of claims that can be intimated against care providers, and then go on to look at recent trends impacting upon the sector. I'm then going to come on to talk a bit about how to manage the risk of those claims when they do come, or how to avoid those claims coming, and also look at some practical insurance considerations for you as well. So before, well, I'll just pass over to Lynn and let you get started, Lynn.
Great, thanks very much, Carly. Afternoon, everybody. And so, yeah, I'll just launch into my section first. So I'm going to start by having an overview of some of the types of claims that can be brought against care providers. But firstly, I just want to touch on the range of things that can flow from a single incident. So you see from the slide there, you've got one incident, and the consequences of that incident are numerous. You can have everything from a potential investigation by the health and safety executive or another regulator, which could lead to enforcement action or criminal charges being taken, or a civil damages claim, which is part of the discussions of what we're going to cover today. In really serious cases, there might be a fatal accident inquiry, and on top of that, you may be faced with media interest about the incident, whether that's local press coverage or national in some situations. And other consequences can be within the organisation itself. So if you've got a need to conduct a health and safety review of what's happened, or potentially some HR considerations in terms of whether individuals need further training or perhaps need disciplinary action, depending on the type of incident that's occurred. So there are a number of things that can flow from one incident, and it is important to be aware at a high level what the consequences of failing to comply with them are, and today's focus is the civil claims that can flow from that. But in terms of looking at very briefly the legal framework that we're operating in on the next slide, it sets out the Health and Safety at Work Act. So in addition to your common law duties to take reasonable care, the Health and Safety at Work Act is the main piece of legislation in the UK that is often relied upon to form the legal basis of the civil claims for damages against all sectors, but focusing on the care sector today. And on the slide, I've just noted there the key duties under that act. The first being a duty on employers under Section 2 to ensure the safety of their employees as far as is reasonably practicable. And there's then a separate duty under Section 3 to take the same care for persons who are not employees, but may be affected by the company's operations. So really between these two sections, it covers almost everyone that's going to come into contact with your care home. Section 3 would apply to anyone that's not an employee. So that could include your patients, your residents, visitors, inspectors, contractors, and that's not an exhaustive list. But what's important to flag is the requirements under Section 2 and 3 is to do everything that could reasonably be done. And so that's more than just the minimum needed for the safety of employees or other persons. It's everything that could be done, unless for some reason it was unreasonable to do so. And what is reasonable will depend on the circumstances of an individual case. On the slide, I've also noted the corresponding duty under Section 7 for employees to take reasonable care for their own safety and for those around them, and to cooperate with their employer on health and safety. And an employee doesn't need to be in any sort of supervisory capacity or have any specific health and safety responsibility connected to that role, but employees' duties of care do come into play in terms of civil claims against the care home sector, whether that is to provide a full basis of defence or an argument that they've contributed to the incident. So if we turn now to look at what we do with all these duties, there are several duties on care home operators, but where do you start with trying to comply with all of those? Well, helpfully, the Health and Safety Executive has issued some guidance specifically for directors and business owners and managers on leading health and safety at work. This is a free and it's available on the HSE's website. It is worth a read. I've just highlighted some of the key points from the document on the slide. The essential principles as the HSE sees it: strong and active leadership from the top. So the HSE wants to see senior staff setting an example, which can be as simple as a director wearing the same PPE as other employees when they're visiting the premises. Next is worker involvement. So there's an expectation that employees are going to be part of the process of ensuring safety. So if that could be them being involved in team training or reporting systems for any concerns. And then finally, there's assessment and review. And the HSE emphasise that monitoring and reporting is vital to ensure that your procedures are working as intended and that remedial action is planned and actually taken. So prevention is, of course, better than cure, and taking the lead on health and safety before an incident occurs will reduce the likelihood of a breach and therefore the likelihood of a claim. But not all incidents can be avoided, so I'm going to now cover the main types of claims that we are seeing facing the care sector. So if we turn now, first I'm going to have a look at the three key types of claims that can be brought against care home operators. And the first type to discuss is claims made by or on behalf of residents or service users. And these claims often relate to allegations of substandard care or treatment being provided to residents, which has resulted in loss and or injury. Care providers have a legal duty, so far as is reasonably practicable, to protect the health, safety and well-being to those that they provide care. Any breach of that duty can result in a negligence claim being made by the service user or on their behalf, depending on their capacity and age. So these claims can relate to the conduct of clinical staff as well as non-clinical staff. And in the legal sector, that distinction is important. The factors which a court will deem relevant in any action raised by a resident and the legal tests that the court will apply depend on the role and the qualifications of the person who is providing the care that's been accused of negligence. If it's a non-clinical member of staff, so a residential carer, and they've been accused of negligence against the resident, the court's going to be considering whether or not that carer has breached their common law duty to take reasonable care. So an example of that could be a carer who's failed to follow their training or instructions or failed to use the correct manual handling procedures whilst assisting a resident to move around, and it's resulted in the resident being injured. If we compare that to clinically trained staff, so that could be nurses, doctors, physiotherapists within the care home setting, if they've been accused of negligence by a resident, then the case is likely to proceed as a clinical negligence claim. And the legal test for establishing negligence is different in that context. Broadly, the court will be determining whether or not the clinician in question acted negligently by considering what the hypothetical reasonable clinician would have done in the same situation. So just to put that into practice with an example, you know, if a nurse has given a resident an incorrect dose of medication and that resident ends up becoming ill as a result, the court is going to be assessing whether there's been negligence by considering whether that was something that no competent nurse exercising reasonable skill and care would have done in the same circumstances. So that's, broadly speaking, the first type of claim we are seeing facing the sector. Turning now to claims made by employees or workers. Now, these claims usually relate to accidents or injuries sustained in the workplace. Just as care providers owe duties of care to their residents, they also have legal obligations to take reasonable steps to protect the health, safety and well-being of their employees. And breaches of these obligations can also result in claims called employers' liability claims. and the duty extends to the employee's physical and mental well-being. Employer liability claims can arise from various situations. Some of the potential causes are listed on the slide. You'll note there they can arise as a result of an employee getting perhaps burned whilst they're preparing food or drinks for residents due to equipment being defective. Claims also can arise due to employees being physically assaulted by residents. It's an unfortunate reality that violence in the care sector is a known risk, and if a service user who is known to be aggressive attacks and injures a staff member, the relevant care provider could find themselves liable to compensate the employee for their injuries, depending on the circumstances. Another example is an employee who contracts an illness at work, where appropriate steps have not been taken by the care provider to prevent this, such as providing adequate personal protective equipment. So there are various types of claims that can be made under the umbrella of employer liability claims. One of the main types of claims we see being presented at present is work-related stress claims. Now, stress at work claims are often made by employees who feel like they've been left to deal with excessive, unmanageable workloads without adequate support, and it can result in them suffering from mental health problems, such as a diagnosable psychiatric injury. Now, there are lots of stressors affecting the care sector, and we are very aware of those, and the impact of those very well may be being felt by those working in the industry. But I would comment that stress at work claims, they are tricky, they are complicated, and they are difficult for individuals to pursue. However, it is worth highlighting and remembering that the need to protect your employees' psychological as well as their physical health does apply. Another common type of employer liability claim relates to employees suffering from musculoskeletal problems. In the care sector, it's common for employees to do a lot of lifting and manual handling on a day-to-day basis, and care workers could sustain injuries whilst lifting or assisting residents who are struggling with their own mobility. Now, these injuries could be one-off events, or they could develop over time, and care providers could become liable to compensate employees for injuries sustained during the course of their employment if they fail to take the appropriate steps to mitigate the risks, for example, involved with manual handling. So if that's a failure to provide your staff with adequate training, or to inform them of appropriate lifting techniques, or by failing to provide staff with the necessary equipment to lift patients, such as hoists, etc. So that's your employer liability. And then if we turn to the final type of claim to mention, and that is claims made by members of the public. So these claims can be brought forward by anyone as a member of the public that's visiting your care home. That could be relatives of residents, it could be suppliers, contractors, public authority inspectors. And again, a non-exhaustive list. So care home operators do have duties to the public. That's set out, as I've already touched upon, under the relevant section of the Health and Safety at Work Act. It's also covered under a common law duty of care that care home operators have, and there are similar duties mirrored in the Occupiers Liability Scotland Act 2016. And in very broad terms, it is really all about taking reasonable care to protect those entering your premises from harm. But it is a duty of reasonable care only. Now, members of the public, so public liability claims really can vary in nature. Often they relate to an accident from that the public could sustain at the care facility, such as tripping over something on the ground, slipping on a wet floor, being cut by an exposed sharp object. And care providers could become liable to compensate someone who's making such a claim if they failed to take reasonable steps to prevent that person from suffering a foreseeable loss or harm at the facility. So lastly, I just want to touch on regulatory complaints and health and safety prosecutions. Now, these are quite different and distinct in nature from the other types of civil claims I just covered, but regulatory complaints and health and safety prosecutions can lead to very serious consequences for care providers, and so they are worth mentioning briefly. The Care Inspectorate and the Care Quality Commission are the public bodies that regulate care providers in Scotland and England respectively. It's the role of these bodies to ensure that care providers abide by all relevant regulatory standards. They regularly carry out inspections at care facilities to assess the quality and safety of the services being provided. Inspections may be routine, or they may come about as part of an investigation following a complaint that's been made about a care provider. And if during an inspection or an investigation, it transpires that a care provider is not meeting the required standards, the relevant regulator may take action against the provider, and that could involve issuing warning notices, fines, restricting on operators' ability to take on new residents. And in certain cases, it can result in health and safety prosecutions. Now, principally, these are brought for failures for duties that I've touched upon under the Health and Safety at Work Act, where there's been a material breach of health and safety. It's important to flag there doesn't actually need to be an injury itself, it's only the risk of one, and prosecutions can be made against both the care home and individuals, and the penalties that can be imposed can include significant fines and against individuals imprisonment. So those are the main types of claims that we've been seeing made against care providers at present. I'm now going to move on to discuss some of the more recent trends that we've been seeing in the sector, issues which often are leading to claims arising. So this first slide shows some of the recent fines that have been issued in the sector. These prosecutions were brought by a number of regulators. However, each of these demonstrates the potentially severe consequences of breaching health and safety duties, both towards residents and patients and employees. As you'll see, often fines are easily over £1 million in serious cases. And as everyone will be aware, inflation is rising. So what I've done on that slide is I've added in italics some figures that have been adjusted for inflation. And that just shows that if the same fine was imposed today, it's going to be substantially higher than it was even 2 or 3 years ago. So these fines are just against the business. What about the individuals? I mentioned they could be prosecuted as well. Well, the next slide just has some recent examples of cases where individuals have been fined in the care home sector and even imprisoned for health and safety breaches. And a point to note is it's not always due to a direct action of an individual, but rather it can be inaction by someone in authority. So there is a trend of increased prosecution in the sector. Turning now to arguably the biggest problem in most care providers are facing today relates to staffing shortages. Now, many providers are facing real challenges in terms of staff recruitment and retention, and we're seeing an increasing number of job vacancies in the care sector across the UK. According to a 2021 staff vacancy care services report, almost half of all care providers in Scotland are reporting having vacancies. Now, at this point, I would highlight that there is the Health and Care Staffing Scotland Act 2019, which is aiming to ensure that staffing levels are in place in both NHS and social care settings. However, this is not yet fully enforced. It will be fully implemented by spring 2024, so something to look for coming up on the horizon. Now, there's a number of reasons for staff shortages that we're seeing in the care sector at present. The increase in demand due to an ageing population in Scotland, as well as staff leaving the sector due to burnout, which was caused by working in very challenging conditions throughout the COVID-19 pandemic. But the main point to note for today's purpose is, as a result of those staffing shortages, we're seeing increasing reports of otherwise avoidable incidents occurring in UK facilities, which is leading to an increase in claims made against care providers. So on the next slide, we've just given a couple of examples of recent adverse incidents which have occurred in the UK care homes that were found to have come about as a direct result of inadequate staffing arrangements. These cases highlight how serious some of the consequences of understaffing can be for care providers and their residents. In the first example, an incident which occurred at a care home in Cheltenham, the operator of the facility was fined just under £500,000, and late 2021 after a resident named X was attacked by another resident named Y. X was in their bedroom when Y entered, locked the door and assaulted them. And it resulted in X sustaining severe permanent facial injuries. The staff members who were on duty at the time were all agency workers, and they were unable to get into the room or contact the duty manager, so ultimately had to call the police for help. On the night in question, there should have been at least one permanent staff member on duty who would have known the codes to access all of the bedrooms in case of any incidents, as well as the location of any of the bedroom keys. However, the permanent staff member who was due to work that night didn't show up for their shift, and members of management didn't arrange for anyone else to cover in their absence, which left the care home deemed to be inadequately staffed as a result. The court found that it was an avoidable incident caused by poor management and unsafe staffing levels. And the Care Quality Commission have said that they hope that this prosecution reminds care providers that they must always ensure people's safety and manage the risks to their well-being. Now, the next example on the slide relates to an incident which occurred at a care home in Bedfordshire. Now, the operator of this facility didn't receive as substantial a fine as the last example, but it did receive negative publicity in the national news, which led to reputational damage, and it also was prohibited from taking on any new residents. It came about following an inspector's report that was published in late 2022 that found that residents had been put at risk of harm due to staff shortages. According to the report, residents' basic care and support needs were not being attended to due to there not being enough staff. Examples were given of residents frequently being left over 18 hours without being offered food, and of others being left in wet clothing or naked in their bedrooms waiting for care. And it was reported that medication wasn't being managed safely at the home, and too much reliance was being placed on agency staff. These examples illustrate why understaffing is currently a major issue for care providers. Consequences for residents and care providers, as well as the staff members themselves, can be extremely serious when incidents occur. And in addition to the fines and prohibitions mentioned, it's highly likely civil damages claims were also made in these examples. So turning now to the last trend I'm going to touch on before I pass you over to Carly. Another common issue we're seeing in the care sector today relates to inadequate risk assessment. So we've noticed increasing reports of incidents occurring where care facilities, as a result of a risk assessment being carried out inadequately or not being communicated to staff or not being implemented effectively, is resulting in incidents. And these incidents are giving rise to claims. One of the common consequences of an inadequate risk assessment that we're now unfortunately seeing in care homes is choking incidents. There's been an increasing report of residents who've been placed on soft diets, being given solid foods by staff, which has ultimately resulted in choking incidents and, unfortunately, in many cases, fatalities. Some of the recently reported cases have resulted in the care provider being prosecuted and fined significantly. And in these cases, often there is a risk assessment that has been undertaken. It's identified a control measure of placing the resident on a soft diet, but it's the failure to follow that risk assessment that's been key. And that's occurred due to either a lack of training or a lack of communication, or both. So just touching on a couple of examples on the next slide. The first example on the slide is from an operator of a care home in Clackmannanshire. Again, they're fined this case just over £500,000 to £640,000 at the beginning of 2022 after a resident sadly choked to death on a piece of a jam donut given to her by staff. The resident suffered from dementia and had recently had a stroke, and risk assessments had been carried out to confirm that they were at a high risk of choking and that they were to be placed on a diet of minced and moist food. But the staff member who gave the piece of jam donut had not been given any training on the modified diet or any information about the suitability of certain foods. So the court found that the care home operator failed to discharge their legal obligations to effectively communicate to staff and provide appropriate training. And the second example on the slide was a care home in West Sussex that was fined £1.5 million. That was after an elderly resident choked to death on large pieces of meat that was given to him by staff. The resident had recently been admitted to hospital, where it was determined he should be put on a soft diet due to a risk of choking. And the court found that the care operator didn't keep accurate records and failed to take account of the advice being given by the speech therapist when carrying out the subsequent risk assessments. And in one of the risk assessments carried out by one of the staff at the home, following the discharge from hospital, no choking risks were noted. So like the incidents we've discussed with understaffing, these events, very serious, they're having severe impacts on residents and care providers. And again, it's highly likely that civil damages claims were also brought against the organisations. So these examples are highlighting why it is so important for care homes to take all reasonable steps to prevent foreseeable incidents from happening, which in turn will mitigate the risk of claims. And that's something Carly is now going to discuss in terms of claim mitigation.
Thank you, Lynn. Yeah, I'm going to come on to talk about how to manage the risk of claims. And it's obvious why, given what we've heard from Lynn about the fines, that are made. They are really substantial and significant fines, but there's also a lot of indirect costs to the business also that I wanted to touch upon. So things like lost management time. So it's taking management away from the day job of actually running the home, because they're having to investigate incidents and accidents, complete forms, do an investigation, speak to witnesses, which absolutely has to be done, and it's really important that it is done. I'll come on to talk about that later, but it does have a knock-on effect on the business. In terms of, basically everything that's listed on the right-hand side, it all has an impact on the bottom line of the business. So as well as avoiding the fines, the reputational damage is really, really important. I'll come on to talk a bit about that later on also. But, this is why it's so important to put in place mitigation measures now. I think the reality is that the incidents will happen. With the best will in the world, is they will happen and claims are likely to be made. But that said, there are ways for care providers to manage the risk of those claims being made against them, and to try to prevent or minimise claims, or be able to repudiate claims that are made against them. So, some of the points that I'll cover will probably seem basic and common sense, but they're absolutely essential, which is why I've included them by way of reminder. Now, risk assessment, absolutely a key pillar of any defence. So Lynn has talked about that in terms of mitigation of the risk of claims, but it's the first thing that you'll be asked for probably after the accident and an incident report. And if it's insufficient or lacking, then that's often used by pursuers agents to form the basis of any claim made against you. And likewise, as I say, it forms a key, a good risk assessment will form the key pillar of a good defence. So it's therefore vitally important for care operators to ensure that adequate risk assessments are carried out in respect of each individual using the service. Now, they should seek to identify potential hazards, obviously look at the likelihood and severity of incidents associated with that hazard, and then put in place appropriate and proportionate control measures. I think that is an important point, because often you can't negate the risk altogether, but that's not what the court's looking for. They're looking at whether measures have been put in place in all the circumstances, were they reasonable to reduce the risk to the lowest level practicable. As Lynn said, staff members need to be made aware of any risk assessments and the implications. So it's not enough just to have one and they're all neatly in a folder and they're there. They have to be communicated, and ideally you want a written record that it has been communicated to staff, it's been made readily available to them, they've been given the appropriate training so that they know what is contained within the risk assessment, and they can effectively implement the control measures in place. It's not enough to do it once because things change, so regular auditing and review of the assessments to ensure they're still appropriate, that's also key. And that's something else a court will look at. So was it looked at, reviewed, considered at appropriate intervals, active open communication with staff members to report any concerns or suggestions related to safety or risk management. Lynn has already talked about that being one of the essential practices of the HSE recommend, but it's the, it's the frontline staff implementing the practices, the policies and the procedures on a daily basis who are often those best placed to highlight any practical difficulties with a system that's been put in place. And I think as a responsible care provider, you want to show that you have that open dialogue with staff. It's a dynamic risk assessment, so it's adaptable to change. As I say, it's not done once and never looked at again because circumstances will change, patients will change, the care will change, and the requirements will change. So all of that has to be looked at. Lynn obviously spoke about staffing issues, and I think it is important to ensure adequate staffing levels. I know that's difficult at the moment, it has been for a while. But having appropriate staff, making sure the staff are competent and appropriately trained. They have to be competent and they have to be well equipped to be able to manage risks and deal with potential incidents. So they have to be trained, they have to be familiar with the care provider's policies, the procedures, the risk assessments. And also knowledge sharing is so important. So in terms of managers being easily contactable should any issue arise. And I think that's one of the examples that Lynn mentioned earlier, was that actually they couldn't get hold of anyone who was permanent. The over-reliance of agency staff, we've talked about that, but just again making sure sufficient numbers of permanent staff members are on duty at any given time. And again, that ties into the Act, the Health and Care Staffing Scotland Act, which Lynn talked about briefly. That also gives the Care Inspectorate more powers to monitor and regulate staffing levels within care homes. So I expect that you're already doing this, to look at your staffing arrangements now and to take any steps to rectify any potential problems that may come once the Act is fully implemented. Just finally for me, touching on insurance, because insurance is absolutely key to have in your armoury for any claims defence, and I just wanted to touch upon, it's the next slide, please. Just talking about basically having adequate insurance cover in place to be able to protect, sorry, I'm actually going to mention the Health and Safety app before I do that. Just the Health and Safety app is something that is free to download, and the reason that I'm mentioning this is because we've talked a lot about investigation and having a system in place and having records, and the Health and Safety app allows you to do that. So it's free to download, and we can send out a link for that after the seminar. But sorry, now on to insurance, and the next slide again, please. So just key considerations, absolutely vital, cannot stress it enough that care providers ensure they have adequate insurance cover in place. So in the event that an incident does occur that will lead to a claim being made, there is that cover there. Now, all care providers, I'm sure, will have an insurance policy in place that covers various types of civil claims. But what I can't emphasise enough is the need to consider whether all potential risks faced have been accounted for when cover is arranged. Now, the main ones are obvious, so EL claims we've talked about, and obviously that's a compulsory form of insurance for anyone who's an employer in the UK, and that does exactly what it says. So any claims made by employees, and it covers compensation that has to be paid out, as well as any legal expenses incurred. Lynn talked about the distinction between medical staff and non-medical staff. So you've got medical malpractice cover to protect healthcare professionals and the care providers that employ them. And that's really looking at the financial consequences arising from any clinical negligence claim. Got professional indemnity cover that's similar, bit of a wider reach. So that can cover mistakes made, including non-clinical staff members, which end up giving rise to a claim. Public liability, Lynn talked about, so that's the non-exhaustive list of people coming to the premises. So, they trip over a piece of loose carpet in a home, slips, trips, falls, occupiers liability, and that's public liability cover. Buildings and contents, designed to cover the cost of repairing any property damage, and that could cover, office equipment, mechanical equipment like lifts and hoists, etc., as well as the actual building itself if the care provider owns that. One that might seem less obvious, cyber liability insurance. That's been taken out more commonly by organisations across a wide range of sectors to protect a business against potential consequences of data breaches. Now, as care providers, you're almost certainly going to store personal, sensitive, protected data in terms of the service users, such as medical records. So I would suggest it is prudent to have some cyber cover in place also. And business interruption covers, so the loss of income suffered due to being able to carry out your business as some sort of unexpected event. And obviously there's a whole BI around COVID, which I'm not going to go into today. That's a separate seminar, but I'm sure you've read about it and are aware about it from the press. So, you know, practical reminders, just the next slide, please. Really, just as I say, being aware of key terms contained within any insurance policies. So actually sitting down with your broker, dusting off the documents, looking at what is the cover, is it adequate, what are the limits, what's the extent, are there any exclusions, everything that you need to be aware about to make sure that you are covered in the event something should occur. You should be aware of any relevant time limits for making claims and for notifying insurers of any incidents. And also looking at the level of deductible or excess that you could be liable to pay in the event of a claim being made. It's advisable to inform insurers of any incidents as soon as possible after they occur. The policy often requires immediate or prompt notification of any incidents or potential claims. So a delay could end up with indemnity being refused. So you want to obviously avoid that. I think the other key point about early notification is that also it allows insurers to become involved and take action right away. So I think what to remember is insurers are vastly experienced at dealing with the claims and the type of business that they write. So, you know, by getting them on board and getting their claims team on board and any lawyers that they want to appoint, then it can help to avoid mistakes being made in the claims handling processes. So ultimately mitigate the extent of any damages being payable or any admissions being made that perhaps shouldn't. You know, there's sometimes a moral obligation to make an admission which, you know, ultimately could cause problems later down the line. So reputational risk also, we mentioned that earlier, but that really is key, and we're often instructed at a very early stage when something has gone wrong to advise on exactly that. So it's not just the legal liability, but in terms of reputational risk, how best should the business operate to, you know, what is the response, what's the appropriate response, how do we help protect the reputation of the business? As I say, by sending insurers all of the available information and documents following an incident, even if it doesn't seem relevant at the time, it's absolutely best to keep your insurers fully informed, and it puts them in the best possible position to help deal with any subsequent claim that is made. I've said this on the slide also, just about talking to insurers before making any admissions, and that's often a term of any policy, that no admission should be made without first speaking to insurers. And again, that could have indemnity complications also. And lastly, just as I say, and I have said this already, but it's very important to review your existing policies to ensure there's no gaps in cover. Is it claims made? Is it claims occurring? Your insurance broker should be able to help you with that. And I think with that, we have just 5 minutes left to cover questions. So I'm just going to have a look, and there's one here that I can answer very easily, and it is are fines insurable? No, they're not, sadly, I'm afraid. So the cover that you're likely to have will cover things such as legal representation in terms of the cost of responding to something like a prosecution, but the fines are not covered and they have to be paid by the business. There's one for you probably, Lynn, and we've talked a lot about risk assessments today, so it's a good question. Are there other tools to mitigate the impact of claims?
Yeah, well, I suppose my top tip on that would be keeping a hold of your paperwork. So gathering the evidence if there's been an incident as soon as you can. So finding out what's happened, who's been injured, who saw it happen, you know, why did it happen, but keeping that paperwork, because that is what's going to be relevant when you get the likes of me or Carly coming along trying to investigate and defend the claim that's brought against the care home, which often can be years down the line. So it's capturing that evidence and sort of putting it in a time capsule so that when we come along a few years later, it's all there, the training records, the personnel files, the records of PPE and the risk assessments that we keep talking about, and having some sort of systems so that you can make those sort of things easier to find is very helpful for being able to defend claims. I suppose the other thing I would maybe touch upon is major incident protocols. They can be really handy to have ready and prepared in advance. Obviously, no one wants a major incident to happen at their organisation, but if something does happen, it can be really helpful to have a step-by-step guide about what you do, who you contact, what information you should gather. It can even have sort of draft wording for statements that go to the press, so you're really ready and not caught off guard. And that's something we've helped clients with in the past, and I'm more than happy to pick up with anyone separately if it's something that they look for assistance with.
Yeah, I suppose the other thing that I would add to that is that, we've talked a lot about the kind of staff turnover, staff shortages, and the sort of transient nature of it. So, although an incident happens, a claim may not be made until 3 years down the line, by which point the staff have moved on. They've, so actually securing the evidence at the time it happens is so important in terms of knowing what happened and being able to decide whether it's one that ought to be repudiated or not, and giving us the best chance at doing that. So I absolutely agree with all of that. It's key.
Yeah, and keeping a note of their name and whatever their contact details were at the time, so that you can try and trace them 3 years later.
I know, when they can't remember anything about it. Yeah. Okay, I think that was all the questions we had. Thank you to everyone who has joined, and I hope that has been of use. This is one of a session or three in a row we're doing on for the care home sector. So the next one is just on the slide here on the 23rd of May, which is about renewable heating systems, which is not our area. So that will be Sarah Jane talking about that, but it's on the 23rd of May. But yes, thank you to everyone for attending, and we hope to see you all soon. Thank you.
Thanks, everyone.